All right, we're back on the record in the Johnson versus Johnson, and this is here, if I understand correctly, on your motion to alter or amend the final decree.
That is correct.
You wish to make an opening statement?
Just very briefly, Your Honor. We're basically here. So the parties were divorced. There had been a divorce complaint filed in October of 23. The parties had separated in April of 22. So at least a year and a half or so, they were separated before the divorce complaint was filed. Of course, the wife was the petitioner in this matter. Mr. Johnson was not aware of the court date. The court date came, and there were certain findings that were incorporated into the divorce decree. Your Honor, we're essentially here on 5 issues, and those issues are that the wife, Mr. Johnson, withdrew his Vanguard retirement in 22, a year or so prior to the divorce even being filed. So he withdrew his retirement, and that amount, Your Honor, was $56,152.73. As Your Honor knows, there are taxes that are withheld from the retirement, and then at some point, he has not filed his 23 taxes yet. I do believe he's filed his 22, but I'll clarify that with my client. But there will also be a 10% early withdrawal penalty that would be assessed. So within the terms of the divorce decree, the wife was granted a judgment for 1/2 of the whole amount of the amount that was withdrawn, which in reality, that's not the amount that was received. If she received 1/2 subsequent to the taxes being paid, which the taxes were withheld prior to Mr. Johnson receiving any money. And then the 10% penalty, she would only be entitled to $19,653.46. And I would submit, Your Honor, that the proof will show that it's only fair if she's going to receive half, she should receive half of what actually was realized. And it will also be our position today, Your Honor, but for those monies being withdrawn by Mr. Johnson, what got paid by Mr. Johnson would not have been able to have been paid by Mr. Johnson, but for those monies. So she's already benefited from those monies being available. Mr. Johnson was the only party who made any house payments from the date of separation on April 22nd until the date the house sold. We have no evidence. We would submit that will be, I do not believe there will be any evidence submitted that will show that Ms. Johnson paid one house payment. Also, Your Honor, the proof will show that between the date of separation and the entry of the final decree of divorce, that Mr. Johnson paid some $94,000. Let me make sure that number is correct. Between $89,000 and $94,000 in payments, house payment, pool payment, car payment, sports fees for the party's children, medical payments, medical insurance, vision insurance, dental insurance, direct payments to the wife, payments for items requested that they be purchased for the house and for the children, and then direct payments to the children. And so, Your Honor, what we're asking Your Honor to do is to take those payments into consideration when it comes to whether or not the judgment in regards to the Vanguard account, whether or not that will stand or will it be reduced. Child support arrearages were calculated in this case from the date of separation through the date of entry of final decree of divorce. And the amount of the judgment that was entered was $26,016. And Your Honor, we're asking that that be reduced today to $0. Again, Mr. Johnson paid over $94,000 in expenses that benefited the family and the children. And those should have been presented on the day that the hearing was held. The court did not have enough information to simply just reduce a child support arrearage judgment. And also, Your Honor, the complaint for divorce did not request that the arrearages be calculated retroactive to the date of separation.
Child support payment at any point during this pendency of this case?
No, Your Honor, not during the pendency. There was no child support calculated whatsoever until the default hearing. So, Your Honor, our position is that Mr. Johnson should have received credit for what we routinely call family support, and that in fact there should have been no retroactive child support arrearages. And if the court does deem that there should have been, then Your Honor, we would ask for it to be recalculated from the date the complaint was filed, which was October 11 of 23. Instead of going back to April of 22. And we're also asking for it to be recalculated, applying insurance credit as the calculation that was arrived at did not have any insurance credit. And Mr. Johnson was in fact insuring. At that point, it would have been 2 children and then subsequently the youngest child. And then, Your Honor, as far as the current support that was calculated, it would be our position that that again needs to be recalculated, applying the insurance credit in the calculation. And that calculator, the child support worksheet, gave Mr. Johnson 0 days and the wife 365 days. Mr. Johnson was available to have these children in his care. Now, they weren't, and they didn't visit. They were older children, well into their teens. And I mean, this was a tenuous situation, but he was available, and it was just
Being available, does that count as a day under the child support guidelines?
often. I will say this: the child.
Agree with it or not? Is that by definition a day that?
I don't know that it is, but certainly it's punitive if you simply, you know, say he gets no days. I mean, he could have visited. He would have liked to have visited. In fact, there were days where he did take at least one of the children to ball games that were out of town, and so he did spend some time with the children. And then, Your Honor, we have the issue of whether or not Ms. Johnson is entitled to any funds that were in arrearages as far as the house payment. Mr. Johnson was ordered to bring the mortgage payments current within 60 days. He did not have the ability to do that. And then to get into the calculation as to how much principal would there have been if he had paid if he had brought every payment current within those 60 days versus how much was the payoff of the home when the property sold. And I don't think there's anyone here today that's qualified to testify as to what that difference would have been. So anything that was owing on the home was paid when the property closed, when it was sold, and that was paid right off the top. So they've already each paid half of those, which in my position would be is that that's equitable. And that's what the court's mandated to do, is to make an equitable division of the marital property and the marital debt. And so just assigning everything to the husband because he wasn't in court on the day the hearing was held, that is not equitable. So all we're asking Your Honor to do today is to go back and look at these issues, and based on the proof that's going to be before you today, is to amend the final decree of divorce so there is an equitable division, and to amend those child support arrearages to 0 based on the support that Mr. Johnson paid from date of separation through entry of final decree of divorce.
All right.
Yes, Your Honor, if I could just briefly.
I represent Ms. Johnson in this matter.
And as Ms. Salinas stated, these parties separated in April of 2022. The parties had 4 children born of their marriage. Mr. Johnson left the marital residence. The testimony will be that the basis of the divorce on the grounds of inappropriate marital conduct was Mr. Johnson's solicitation of prostitution, and frequenting and having extramarital affairs and using marital funds to satisfy his sexual proclivities. So again, that's relevant in the fact of that there was significant grounds for divorce in this case. And he had been gone from the home, and he had left the home in April of 2022. And at the time, the 4 children were in the home. At the time, the children were 18. The youngest one just graduated this past May and turned 18 in June of this year. So the complaint was filed. The divorce was granted on the 3rd day of April. And in that divorce decree, Your Honor, in 2024, Mrs. Johnson was granted divorce on the grounds of inappropriate marital conduct. And again, it was the marital residence was to be sold and the proceeds divided equally between the parties after the payment of the indebtedness, cost of sale, and loan on the pool. That's important to note because on the same day and date that my client was appearing in court before Judge Lockhart Mash, Mr. Johnson, the testimony is going to show that Mr. Johnson borrowed an additional $20,000 on the home and forged Mrs. Johnson's signature on that and had his aunt notarize the signature on that, and he acquired $20,000. So again, the proof is what did he do with that $20,000? Because during the pendency, after the divorce was granted and Mr. Johnson retained Ms. Salinas and he filed a motion to set aside the final decree, the payments became significantly delinquent and the property was in jeopardy of foreclosure. In the fact that it was going to be, the property was supposed to be sold back in April of 2024, Mr. Johnson, who had historically, and the testimony would show, had historically paid the mortgage and the pool payment, that he would continue to do that. And he would bring any payments current within 60 days. And he would provide proof within 10 days to do that. When we came back to court in October on the motion to set aside the default that was amended pursuant to the order to a motion to alter or amend, the house was finally sold. And the money has been deposited into court, and his half of the money has been deposited to the tune of about $78,000. In addition to that, Your Honor, the judgment on this is that the wife was to receive judgment in the amount of $28,076.36, which represented her half of the retirement account from Vanguard. In 2022, during the separation, after they had separated, but before the filing of the divorce, Mr. Johnson withdrew some $56,152.73 from the Vanguard account. And again, there would have been a qualified domestic relations order, and she would have gotten half of that, and there would have been no taxes. He unilaterally withdrew it and had to pay $11,230.54 in taxes, according to the 1099-R form that was submitted through his company. The retirement account was with Vanguard through CVS Health, and as of the date of 12, it had lost some money from market gains and losses through 2022, and he cashed it out. And as I said, that amount that he received was some $56,000 and some change, and she was entitled to half of that judgment. And again, we've got the 1099 to illustrate what he got. So if it had been there, then she would have had that rolled over. Historically, what the court needs to understand is that these parties had a long-term marriage. They were married in 1998. They had 4 children. For the most part, my client was a stay-at-home parent. She went back to nursing school in 2010, I believe it was, is when she started, 2014, excuse me. She was a stay-at-home mom and worked as a tech, but she started nursing school in 2010, graduated in 2014, and began working in 2014. So for a big significant part of this marriage, she was a stay-at-home parent and did not have was not the primary breadwinner, and she did not have a retirement account. So these funds were crucial to her to fund a retirement when she reaches that age. So again, to ask for an offset for taxes for him unilaterally cashing it out. And the question would be is as Ms. Salinas has stated, he's not filed his 2023 taxes nor his 2024 taxes. So they come to court on a motion to alter amend, not fulfilling their obligation to produce their income. There's no tax records to be filed because he hasn't filed it. And again, I'm standing here and I apologize for not knowing because it wasn't provided in discovery. I don't think he filed his 22 taxes either. And so again, if they're going to ask for this offset on this judgment for the retirement account, we need to see the 2022 taxes, and I don't think those were filed. If they are, I'm mistaken, but we haven't seen them. Additionally, in here, Your Honor, there was a judgment for medical expenses. Again, Mr. Johnson terminated my client's insurance without notice and telling her she had a medical emergency and incurred $4,422.38 in medical expenses when she did not have insurance coverage. And again, pursuant to the notice requirement under the statute for health insurance, he was obligated to provide that, or his employer was obligated to provide her COBRA, a notification of COBRA. That was not done, and the judgment was taken. Additionally, Your Honor, there was a retroactive support judgment that's contained in the parenting plan. And there are child support guideline worksheets attached on each one of those because, again, the children were were getting emancipated and aging out throughout the course of this time. And so the child support judgment is self-explanatory. And on those notes, Your Honor, right there, again, this is a Rule 59 motion to set aside. And Your Honor is aware that on the motion to alter or amend, the only thing that this court can do is to correct errors of law or fact, procedural or evidentiary errors, clerical mistakes, or to be in the to prevent manifest injustice. So that's the standard that has to be proven that one of those things occurred before Your Honor can alter those. So again, if you look at just the judgments that we're trying to enforce in the final decree, from his $78,000, his half of the equity that's deposited with the court, the judgments are $58,514.74. And that's without post-judgment interest. He was ordered to pay child support for their one remaining minor child, and his child support obligation would have ended last month, June of 2025. His child support obligation was $775. And so I will tell you, in looking, if you want to look at the child support worksheets that are attached onto that, there was no credit for health insurance. But we don't know how much his health insurance for only the one child is. He has produced information saying he has health insurance, but the only information that he's produced post-hearing was that it cost, I think it was $330 some odd dollars. But again, that's not a breakdown, and there's no evidence or documentation from his HR to show where it came from or whether it was private pay, because we're only talking about what the cost is for this one child. And that's not been provided to us through discovery. So again, from a motion to alter or amend, if there was a clerical error because his health insurance was not included, he wasn't here to testify. And it was not there to do it. But again, what we have to do is do that. But then again, we have the secondary problem with is this man hadn't filed taxes for 2023. And so again, to reflect what his income is in 2023, because he also during the course of the marriage, He has a shade tree type business wherein he does people's, and again, this is kind of funny to say that the man who hasn't paid his taxes, he prepared people's taxes for them on the side. So again, we're not going to have any proof of what his income is because he hasn't done what he's supposed to have to done. So again, 775 from April of 2024, when the divorce was granted, until June of 2025 is a total of 15 months. He should have paid $11,625 in child support. He made two payments on October. He made three payments, one on October 31st, and then he put two together on October 11th. So he deposited with the Child Support Receiving Agency $2,325 in 2024. And in 2025, on May of this year, May 5th, the Child Support Receiving Agency evidenced a payment again of $2,325, which is basically another three payments. So if you take out the payments that he owed, the amount he owed minus what he paid, he owes $6,975 in retroactive support. And then goes to the issue of the $20,000 debt that he obtained. And this is where it becomes, he was ordered in the divorce decree to bring the payments current. The mortgage and the pool payments. Of course, when they were before the court, they had no knowledge of this debt that he took out on the date of the final decree. But that was paid off on the closing. Mr. Bronner McCoy closed the property, and what was paid on this post-judgment debt of the husband was $20,125.54. We are asking for that amount to be reimbursed to her because, number one, it was a fraud. It was a fraud that he obtained after the filing of the divorce in violation of the restraining order that he was served with. He incurred credit. And the reason we're asking for all of it, he was ordered to bring those current. We're not going back and saying, Judge, because he didn't make these payments, this is the difference in equity that they would have gotten. We're not trying to double dip. It's just the 20,000. So with that, of the 78,000 there, he owes approximately 75,000 to her.
75,000.
Yes, Your Honor, the 58,000 plus the 69 and the 20,000. And then of course, whatever attorney's fees that may have been incurred.
Well, I'm glad we're going to start off the month of July with a simple, uncomplicated case. Ms. Salinas, it's your motion. You may call your first witness.
Sure. I didn't mention this, and I should have, but there is also a motion for return of husband's personal property, and I don't need to have that is before the court.
All right.
All right, Your Honor, I'll call Mr. Johnson to the stand.
Johnson, if you'll come right up.
Those are the bank records.
Yeah. Your Honor, just so I don't forget, I do have Mr. Vinson's bank records, and an affidavit of the custodian records that I would like to evidence. That is, we've agreed that these can be submitted under seal.
We'll mark them as Exhibit 1 then.
Mr. Johnson, state your name, please.
Troy Bruce Johnson.
All right, and you were married to Stephanie Johnson, is that right?
That's correct.
And you heard Ms. Roberts state that you'd been married for several years. How long had you been married?
Since September of 1998.
1998? Okay, and you had 4 children together, is
Yes,
that
ma'am.
right? And when did you separate?
on April of 2022.
All right. And when you separated, did you leave the marital residence?
Yes, ma'am.
And were you asked to leave?
I was.
Who asked you to leave?
My ex-wife.
Okay. And where did you move to?
Originally, I moved to a hotel because I wasn't sure how long the situation would last. And after about 8 weeks, I obtained a separate residence in Clarksville, an apartment.
All right. And do you live in Clarksville currently?
Yes, ma'am.
Okay. And so you had cost associated with the hotel when you moved, is that right?
Yes, ma'am. It was about $460 a week.
A week, all right. And then what is your rent in Clarksville?
$1,280 a month.
And what was it when you first moved?
1,180.
So it's increased since
Yes.
you moved. All right. And sir, when you left the marital residence, were you paying certain expenses to benefit the family?
Yes, ma'am.
And tell the court what those expenses were.
At that time, fixed expenses were the mortgage, the house note. I also paid for a car note, a 2016 Honda Accord.
And who drove that car?
Stephanie.
And Stephanie was your wife?
Yes.
Okay. And what other payments?
We had installed a pool, and I was paying the pool payments at that time.
All right.
I also covered groceries quite often.
Okay.
I covered, let's see, a health insurance. I carried everybody on my health insurance.
Okay.
Um,
Did you pay some expenses for you? Did you have a daughter attending Tennessee Tech?
Yes, ma'am. When Kayla first went to Tennessee Tech, we made the decision that we were not going to make her take on student loans.
And who's we?
Stephanie, well, my ex-wife and I.
Okay.
And with that, I paid Kayla's first year of Tennessee Tech out of pocket with money that I could drum up.
Okay. And then were there some miscellaneous expenses that you also paid? Just some expenses here and there that you paid for the benefit of the family?
Yes, ma'am. I paid I have an HSA account that I've put in money for that is withdrawn. Oh, it's not withdrawn, sorry. It's funded pre-tax, and that is eligible for any kind of medical expenses, any kind of prescriptions, any kind of things that have to do with the medical side of our family cost. So I wasn't using that, but that was available for them to pay off whatever debts or any kind of incurred expenses.
Okay. And then were you also sending Venmo payments to your wife and the children
Not while I was there. I was after the fact.
after you left the house?
Yes, ma'am.
Okay. All right. And was your wife working when you separated?
Yes, ma'am.
What was her job at that point? in
She
time?
was at that point, I think she was a travel nurse.
A travel nurse? Is she a registered nurse?
She is.
Okay. And was her income comparable to yours?
Yes, ma'am.
All right. Your Honor, may I approach the witness?
You may.
Mr. Johnson and Ms. Roberts, I'm just going to do these like one and such.
Not the son.
No, I'll be exactly.
Okay.
All right. Let me look. All right, sir, what do you have in front of you?
This is a payment history from Lakeview Loan Servicing Company.
And what payment was associated with Lakeview loan servicing?
This was our primary mortgage.
All right, so that was the house payment. And how much was the payment per month?
It moved based on the escrow,
Okay,
but on May 10th of 2022, it was $2,181.78.
How much?
$2,181.78.
all right. And sir, did you make that payment on May 10 of 22?
Yes, ma'am.
And then if you would just go through, now you provided me with bank statements and such, and those payments to Lakeview loan servicing, those were paid through your bank, is that right?
Yes, ma'am.
And who do you bank with?
First Financial Bank.
Okay, all right. And if you would go through and if you would look at the dates of the payment and then the amount and just tell the court what payments were made and on what date?
All of these.
Yes, sir.
On June the 1st of 2022, I made a payment of $2,257.39. On June 22nd of 2022, I made a payment of $2,257.39. On July 26th of 2022, I made a payment of $2,257.39. On August the 30th of 2022, I made a payment of $2,257.39.
Your Honor, again, I don't mean to stop the thing, but there are bank records and a summary sheet. I don't see the necessity of going, I mean,
I would
And
think that
that's
would
fine.
speak for
Okay.
itself. It's been identified, so.
And that's fine. So Mr. Johnson, did you make a total of $34,149.96 in house payments to Lakeview Loan Servicing during your?
Yes, ma'am, from May of 22 to July of 23, that's the amount that I paid.
Okay, Your Honor, and if I can have that back.
All right. We'll mark that as Exhibit 2.
Yes, Your Honor. And then, sir, if you would look at the next one, and we'll do the same thing. What was Capital One? What debt did that signify?
Capital One was the company that I used to finance the 2016 Honda Accord.
And again, who drove the Honda Accord?
My ex-wife.
And at some point in time, did your daughter take the vehicle over?
Yes, ma'am, that car was given to her when she turned 16.
All right. And when did she turn 16?
June 28, 2023.
Okay. All right. And then you continued to make those payments. Is that right?
Yes, ma'am.
And so again, she would have been under 18 when you were making those payments to
Yes,
that
ma'am.
car. All right. And so your first payment that's on the sheet, is it April 25th of 22?
Yes, ma'am.
And then if you would flip over and look at the next sheet, when was the last payment made?
In May the 6th of 2024.
And you made all the payments listed on this sheet. Is that right?
Yes, ma'am.
Okay. And what were the payment totals?
$11,148.34.
All right. And again, this benefited your wife and your daughter. Is
Yes,
that
ma'am.
correct? Your Honor, we'd move to mark this as the next marked exhibit.
Okay, Exhibit 3.
And sir, I'm going to pass you up a document that says file gift. What was that debt associated with?
This was the credit union we acquired the swimming pool loan through.
When was the pool built?
It was built over the winter time of 2021 and 2022.
Okay, so recently, just prior to your separation, is that
Yes,
right?
Yes,
Okay, and the payments that are listed on this sheet, they are from when to when?
from May of 2022 to October of 2023.
Okay, and the payment amount, how much was it?
551.26 was the fixed amount.
The fixed amount, but was there, it looks like there was a time or two where you paid less and a time where you paid more. Is that correct?
One time, yes, ma'am, I paid
Okay.
$700 in October of 2023. I don't know what these little 37 and 17 cents charges are. I'm assuming they're probably adjustments,
Okay.
but I wouldn't have paid 17 cents. So.
And sir, are you aware of any payments that were made in association with the pool by Stephanie Johnson?
No, ma'am.
Are you aware of any payments that were made towards the vehicle she drove and then your daughter drove by Stephanie Johnson?
No, ma'am.
Are you aware of any house payments that were made during the time of separation by Stephanie Johnson?
No.
All right. And again, you had no benefit of living at the house. Your wife and your children were living at the house. Is that right?
Yes, ma'am.
Your Honor, I'd move to mark the exhibit.
Exhibit 3.
4. And then pass you up. And sir, your health savings account, how did the funds get into your health savings account that you have through work?
They were payroll deduction pre-tax.
Okay, so they were deductions from income that you earned.
Yes, ma'am.
Okay, and that was available to your wife and that was available for the benefit of your children as well. Is that right?
Yes, ma'am. We both had debit cards.
Okay. And sir, if you would look at these medical bills, if you would glance over them and state whether or not, in fact, you recognize these medical providers and payment amounts.
I recognize them just because I've seen them through my statement. I did not handle this account.
Okay,
Stephanie basically took care of the payments to these people. So
to the medical providers.
yes, ma'am, because a lot of it was, we had a child that had, a pretty serious health thing go on and she had, built some additional bills.
Okay.
And I think Stephanie probably just paid payments on those through agreements.
Mhm.
And she used the debit card, the HSA account to take care of that.
Okay, but these medical bills were paid through the HSA account or through your bank statement. Is that correct?
Just through the HSA.
Just
account. Mhm.
HSA. Okay.
Mhm.
All right. And is it true that the payments date from June of 22 all the way through July of 24?
Yes, ma'am.
And what are those totals?
5,513.01.
Okay. All right, Your Honor, if I may move to mark, this is the next marked exhibit. And then we have this one titled Sports, Mr. Johnson. Were your children involved in sports?
Yes, ma'am.
Now, at the time of your separation, you had two children who were under the age of 18, is that right? 22.
You see, Hannah was born in 2004 and her birthday, she didn't turn 18 until October that year. So actually 3.
Okay, all right, but soon thereafter.
Yes,
too.
yeah,
Okay.
within 6 months.
Okay, and what type of sports were they involved in?
Hannah played soccer. Lauren played volleyball.
All right, and so as you're looking at this sheet, if you would tell the court what is listed on here as far as what were you paying? Did you pay these expenses?
Yes, ma'am.
Okay, and it looks like a majority of them were for volleyball.
Yes, ma'am.
All right, and then the National Collegiate, what was that for?
That was a recruiting clearinghouse because at that time we were looking at Lauren going to play volleyball, either mid college or small college. And so that was part of a necessarily marketing her, getting her out there with website stuff and contacting coaches and that kind of stuff.
All right, and then where you see, for example, a charge to Hampton Inn and Doubletree Hotels, what were those expenses for?
Lauren traveled with Clarksville Volleyball Club and they would do out of town tournaments. And some of those tournaments would require overnight stays, sometimes weekends, 2 or 3 days.
Okay,
And that's basically me paying to make sure that she had a place to stay.
okay, and that would have been in 23, is that right?
Mhm.
And did you attend those trips with her?
Yes, ma'am.
Okay, all right, and what is the total for the sports?
5,157.60.
And again, that's from 9/26 of 22 to October 6th of 23, is that right?
Yes, ma'am.
Okay, and again, attached to this sheet is evidence of these charges in your bank statements, or there are, if you would flip over some cash receipts. And were those cash receipts paid, and then the receipt generated to you for that amount?
Yes, ma'am.
And there are 3 of those, is that right?
Yes, ma'am.
Okay, but everything else was generated through your bank statement.
Yes, ma'am.
We need you to speak up a little bit for our court reporter. There you go.
Is this
That
better?
probably helps.
Better.
All right, and then, Your Honor, we would move to mark this as the next.
Six.
And then, Mr. Johnson, the next document that I have passed forward, what is it? Is it insurance payments?
Yes, ma'am.
Now, you provided insurance for the family when you separated, is that true?
Yes, ma'am.
Okay. And you were having the premiums, were they deducted from your paycheck?
Yes, ma'am. They were pre-tax from my paycheck bi-weekly.
Okay. And behind this sheet, do you have a pay stub?
Yes, ma'am.
Okay. And if you would look at the April 22nd pay stub and then go to your family, these were family premiums, is that correct?
Yes, ma'am.
All right. What were you paying for dental?
$27.69
And was that weekly or biweekly?
bi-weekly.
And what were you paying for vision?
$6,
And what were you paying for Blue Cross Blue Shield?
$332.31
All right. And do we have a total for that amount?
for the whole thing.
Mhm.
Just for
The 366, would have that been the total for a biweekly
Oh, yes, yes, yes.
deduction?
That would have been the premium.
Okay. And how many people were on that premium?
All of us, all six of them.
All 6 of you, but only 2 would have been on the child support worksheet. Is that right?
Yes, ma'am.
Okay. All right. Are you asking credit for those insurance payments on your child support calculation when you had the 2 children under 18?
Yes, ma'am.
Okay. And then if you'll flip behind that first pay stub, did your insurance in fact go down at some point? Did your wife come off the premium?
Yes, ma'am.
And you don't deny that she came off the premium,
No,
is that
ma'am.
right?
Yes.
And why did she come off the premium?
We went through a open enrollment in October, which we always do every year.
Mhm.
And if your spouse, according to my where I work, if your
Objection hearsay.
I mean, so you can't say what your employer said, but I'm gonna ask you.
oh, okay, okay.
Was your wife aware that she would be coming off your insurance?
No,
Your Honor, again, I'm gonna object to the form of the question, what she was aware of. I mean, again.
I can
just a formal
rephrase.
question.
It's improper. Yeah, Mr. Johnson, did you and your wife have conversation about her getting her own insurance?
no, ma'am.
You did not. Okay. All right. Did you notify her that she would be coming off your insurance?
No, ma'am.
You did not. Okay. All right. Did you believe she had her own insurance through her employer?
Yes, ma'am.
You believe that she did?
She had the availability.
Okay. Okay. All right. And so let's go through October 23 through May 24, there was a reduction. And if you would look at that pay stub, that second pay stub, what were you paying for dental?
$20.77,
And what were you paying for vision?
$323,
And what were you paying for Blue Cross Blue Shield?
$283.38.
And look and see if you were paying $257.08.
Ms. Salinas, what paycheck are you looking at? I apologize.
It's the, it should be the one, let's see.
Payday
Oh.
11/23.
I think that's the one.
It
Very
is,
last one.
it
The
should
May-
be the, yes,
May is the second one. I need to
Yes.
look at it. October, November. November is $257.08.
yes, it has, payday 11/3/23.
Yes.
Okay, all right. And the total amount of that premium biweekly was how much?
$281.
Okay, and again, and there were not 6 people on that. And I may have that calculation incorrect, so we may have to adjust the final insurance credit. But there would have been 5 people at that point in time on the policy. Is that right?
Yes, ma'am.
Okay. And so we will have to make an adjustment there. But again, at that point, there only would have been 1 child being covered. Is that right? From October 23. Your
Yes, ma'am.
second youngest daughter turned
18.
18 in October. Okay.
Yes.
But when would she have graduated? She wouldn't have graduated till
So
May. Okay. So we know though that the total premium biweekly was $281.08.
Yes, ma'am.
Okay. And Your Honor, there will need to be an adjustment because my math I had kept 6 on the policy and there in fact would have been 5. Are you asking for insurance credits on the child support worksheet?
Yes, ma'am.
Okay. Your Honor, may I move to mark this as the mark with those, with the understanding there. All right. And are you asking the court to also to take into consideration the fact that the insurance payments that you make each and every month for the benefit of the entire family for a period of time, and then for the benefit of the children?
Yes, ma'am.
If you look at this and smart money assistance, what is Venmo?
It's an electronic payment service.
And can you be a recipient and a sender?
Yes, ma'am.
Okay. And in this case, were you the sender?
Yes, ma'am.
Okay. And what does this sheet signify?
Various payments to people in my family.
Okay. And we see Stephanie Johnson, that would have been your wife at the time. Is that right?
Yes, ma'am.
And that would have been Hannah Johnson. Is that right?
Yes, ma'am.
She would have been your daughter.
Mm-hmm.
Megan,
Daughter. Yes.
daughter, and Hannah again. Okay. And what's the payment range as far as the day on this sheet?
From July 27th of 2022 until November 16th of 2023,
And what is the total amount paid?
$6,297.50.
And you have printed out a summary from Venmo, is that right?
Yes,
And
ma'am.
is that attached to this summary sheet?
Yes, ma'am.
And when you made a payment, for example, on the first sheet to Stephanie Johnson, would you typically notate what the payment was for?
Yes, ma'am.
Okay, if you would look on that first sheet, where it says Stephanie Johnson on July 28, 22, what was the notation?
Soccer stuff and backpacks.
And would have that been for the children?
Yes, ma'am.
And then the next one was volleyball fees for Lauren?
Yes, ma'am.
Okay. And again, you can go through and you can see in the memo, so to speak, why you were sending money.
Yes,
Is that
ma'am.
right?
Mm-hmm.
Okay. And if you'll look on, I think it's the second page, there was one that I don't have highlighted for Kayla. Kayla would have been an adult at that point, right?
Yes, ma'am.
But there was a payment for $700. And it says rent at Tech.
Oh, yes, ma'am. That was for her apartment.
So again, you were also paying expenses for your daughter who was at school.
Yes, ma'am.
Okay, but she was an adult and we have not included those in these figures. Is that right?
No, ma'am, I did
Okay.
not.
Your Honor, I'd move to mark this as the next marked exhibit.
Is this 8?
Yes, that's what I have. And then, Mr. Johnson, are you asking the court to take those Venmo payments into consideration in determining whether or not there should be any adjustments in regards to the judgments that were entered against you in the final decree?
Yes, ma'am.
All right, and I'm going to pass you items ordered for the family. If you would explain to the court what that means.
Sometimes they would, my family would come to me and say, hey, Daddy, can you help me with something?
Okay.
And I would.
And would your wife do that sometimes too?
I don't know. I mean, I would assume she would, but I don't know. I don't have her records.
Okay. Who asked you, and maybe no one asked you, maybe you just paid it, for the Genie garage door opener?
That way we discussed that because the garage door at the time at the main residence was becoming problematic. And so, I just bought a new one and installed it.
Okay, at the marital residence?
Yes, ma'am.
All right. And then you bought some wheel rims. Who were those for?
Those were for Stephanie's car at the time, the 2016 Accord.
Okay. And a Dyson vacuum.
Yes,
Who-
ma'am.
Who is that for?
That was for the home. Stephanie was, we had gone to dinner not far before this period right here. And instead, because there was two long-haired animals in the house, the dog hair was almost unbearable. And she went into the new vacuum to handle that.
Okay,
So
and
I bought that.
you bought it. All right. And then Amazon leggings.
Those were Lauren's volleyball stuff.
Okay. And then the Apple MacBook.
That was for Lauren's school.
Okay. And then there was an HVAC repair.
Yes, ma'am. That's Adam Ziegler's HVAC company.
Was that for the marital residence?
Yes, ma'am, for the drain air conditioner.
Okay. And what was the total on those amounts?
3,196.11
Okay. And what was the date range?
from September of 2022 to August of 2023.
Okay. And we have attached verification of your order details for those items. Is that right?
Yes, ma'am.
And Your Honor, I'd move to mark this as the next marked bid. Mr. Johnson, are you asking the court to consider those amounts of monies in determining whether or not there are any reductions to the child support judgment or the other judgments that were entered against you?
Yes, ma'am.
Okay. Now I want to back up while I think about it. In regards to the insurance, was there a deductible for the insurance, the health insurance?
Yes, ma'am. Where I work, they use what's called a high deductible insurance plan. And they couple that with an HSA account that you can also fund on your own. The deductible for a single member family is $3,500 or for individual. And then for family, it's $6,500 before reinsurance kicks in.
Okay, so the medical expenses of your wife that weren't paid, had they been paid, would there have still been a deductible that would have needed to be
Oh, yeah,
met?
yes.
And would the entire, well, if the deductible hadn't been met,
Yeah, object is speculation.
Question is objected to as the calling
Well-
for speculation on his part.
Your Honor, I asked him if the deductible would have had to have been met. I think he certainly would have knowledge of whether or not, just through practical experience, having insurance with deductible. Normally, the deductible has to be met.
Your Honor, in his previous testimony, he said he did not handle the HSA account. He did not do anything about that, and he did not know it. And that he only submitted that document because that's what he looked through his account. He testified he knew nothing about it. So to make an assumption that because he canceled the insurance without notice, that a deductible would or would not have been met is speculation on his part based on his testimony.
Sustain the objection.
Okay. Are you asking at a minimum that your wife be ordered to pay half of her medical bills?
Yes, ma'am.
All right, then I'm going to pass you forward. Titled C&W Pools. Who are C&W Pools?
That's Carl Chambliss's pool company out in Joelton.
All right, and would they come to the pool from time to time at the marital residence? and-
No, ma'am. They basically gave us supplies.
Okay, so you would buy
I
supplies.
would buy supplies from them.
Okay, and in September of 22 and May of 23, did you buy some supplies for the pool at the marital residence?
Yes, ma'am. Salt and such.
Okay, and again, you weren't living there.
No, ma'am.
Your wife and children were living there.
Right.
And how much were those supplies?
$97.24.
Are you asking the court to consider that payment as well?
Yes, ma'am.
If, Your Honor, if I could mark those.
Ms. Tim,
And Tennessee Tech, let me have this. Yeah, this is for your daughter who would have been an adult at that point in time, but again, did you and your wife discuss that you were gonna help her?
Yes, ma'am.
And you did help her,
Yes, ma'am.
and that did come from money that you earned.
Yes, ma'am.
And what amount did you pay to Tennessee Tech in 2022?
2006-14-52.
And are you asking the court to take that into consideration in regards to family support that you paid to benefit the family?
Yes, ma'am.
And if you'll look behind again, is that evidenced, that payment, those payments evidenced by your bank statement?
Yes, ma'am.
Your Honor, I'd move to mark that as the next mark. And then, sir, who's Dickens Turf?
They are a sod and surf and lawnmower company. I think they're in Dixon, Tennessee.
Okay, and what was purchased from Dickens Turf?
This was a lawnmower repair for our zero-turn lawnmower.
Okay, at the marital residence?
Yes, ma'am.
And who was using the lawnmower at that point in time?
Well, I wasn't there at that point in time, so I guess
Okay.
Stephanie was.
Okay, all right, and are you asking the court to consider that payment as well?
Yes, ma'am.
And it was evidenced by your bank statement, is that right?
Yes, ma'am.
All right, Your Honor, I'd move to mark that as well. And then lastly, child support payments. You have, since the entry of the final decree of divorce, do you agree that you have paid a total of $4,650 in child support payments to Ms. Johnson?
Yes, ma'am.
All right, and those are evidenced by a printout from the state, money order receipts, and a cashier's check. Is
Yeah.
that right?
Yes, ma'am.
All right, and are you asking that this amount be applied towards what you should have paid towards child support?
Yes, ma'am.
Your Honor, I'd move to mark that as the next one. And sir, I'm going to pass you up a summary sheet, and you and I have gone over this together. Is that right?
Yes, ma'am.
And all of the totals that we just went over from May of 2022 through the entry of final decree of divorce, how much did you pay?
$94,265.96.
All right. And sir, again, you weren't driving the Honda.
No, ma'am.
You weren't living at the marital residence.
No, ma'am.
You weren't benefiting from that whatsoever.
No, ma'am.
Okay. And as far as you know, your wife didn't make any payments in those regards.
No, ma'am.
Okay. And I don't know if I asked you this, but were you and she earning comparable income at that point in time?
Yes, ma'am.
Okay. All right. What do you earn?
What do I bring home?
Well, no. So what do you do for a living?
I'm a senior financial analyst for a healthcare company.
Okay. All right. And
you making that last statement?
Oh, yes, Your Honor. Yes. All right. If I could move to mark that as the next mark. Thank you. All right. Who do you work for?
Mitchell International and its subsidiary, which is in Light.
Now, the child support worksheet had your income and Ms. Johnson income, her income very close to one another, is that right?
The original one, yes, ma'am.
And you're not disputing that income, are you? Although you may be a bit higher now. Would that be accurate?
Yes, ma'am.
I'll pass this to you. And this is a document that was factored, is that right?
Yes, ma'am.
And what does it have your income being
$6,250
per month?
per month,
And what does it have your wife's being?
$6,500 per month.
Okay, so you both had about the same amount of income per month.
Yes, ma'am.
Have you filed 2022 taxes?
Yes, ma'am.
Okay, and were they requested in the interrogatories?
No, ma'am.
What was requested in the interrogatories and request for production of documents?
2023 and 2024.
Okay, and you have not filed those returns, is that right?
No, ma'am.
Okay, and,
I have filed extensions.
okay, but 2023 extension, in all fairness, would have been October of,
Right. So I have not filed that.
okay, so you're late filing those, is
Yes,
that right?
ma'am. But, yes. Ma'am.
Okay, and do you intend on filing those?
No, ma'am, I'm actually in the process because of, the electronic payments moved, to everything that you received electronically was taxed through a 1099-K. And because of that, I had inventory from COVID that I had sold at a massive loss. And my business that I was supposedly running did not count as a business any longer. The time threshold, it fell under as a hobby. And because of that, I have another accountant looking at it. But as it sits right now, I'm getting a refund of about $750. So I won't be assessed any penalties or interest.
Okay, and that was going to be my next question. With what you do on the side, as far as, work that's not your main source of income, will you show a profit or will you show a loss?
Oh, loss, a
Okay.
heavy loss.
Your Honor, again, I'm gonna object to speculation. He hasn't done his taxes, so how do we know?
Well, Your Honor, I think, let me ask him a question and then I think. she took that.
Pertaining to that question, you can re-answer.
Have you kept records and do you have enough information in front of you to determine whether or not you had a profit or loss?
Yes, ma'am,
Okay, and are you going to have a profit or a loss?
a loss.
Okay, and you said that honestly, what you did or actually what you did or do on the side is considered a hobby.
Because of the time constraints on it. I didn't do it in enough amount of time during the year.
Okay, all right. Did you get to a point where you were having difficulty paying the expenses that you were paying and paying your own living expenses?
Extreme.
Okay, and did it become impossible for you to do that?
Objection to the leading.
So tell the court about your your financial situation. Did you have enough money at the end of the month to pay all the bills that you had been paying?
Not at the end.
Okay,
Not as about October of 2023. At that point, I had exhausted everything in my inventory to be able to sell. And even then I was selling at a loss, a massive loss. But when that cash flow stopped, I had no other income and I couldn't get another job because I work from home and I work from home in 4 different time zones. So I'm supposed to be available from 6 a.m. to 11 at night.
Okay.
And so I couldn't very well skip out and go do anything else.
so there came a point in time where you hadn't paid all the mortgage payments.
Yes, ma'am, I had
Okay.
that or be evicted.
Okay, and you hadn't paid all the pool payments. Is that right?
That's correct.
Now, you heard both Ms. Roberts and myself talk about a withdrawal of a 401k in 22.
Mhm.
Did you in fact withdraw proceeds from your 401k?
Yes, ma'am.
All right, and may I approach the witness, Your Honor?
May.
What was the gross distribution?
56,152.73.
And was in fact federal income tax withheld?
Yes, ma'am, of 11,230.54.
Okay. And so that money was deducted from the 56,152.73, is that right?
Yes, ma'am.
Okay. And sir, at some point, will there also be a 10% penalty that you have to pay?
Yes, ma'am.
Now, this money that you receive from the 401k, how was it applied? Where'd it go to?
I used it to basically support both households.
Okay. And without that money, would you have been able to do so? As
No,
long as you had?
no, ma'am. There's no way.
Okay. Now, you understand in the divorce decree, your wife was awarded 1/2 of this total amount. Do you understand that?
It's 1/2 of the gross distribution.
That's right.
Yes, ma'am.
Okay. And what are you asking the court to do today in regards to that judgment?
I would like for them to take into account all I paid and say, hey, you used this money to sustain the household for 2 years. But if not, at least take into consideration taxes and the
And the
penalty
penalty?
withdrawal.
Okay. All right. So essentially, how much, the penalty would be how much? 10%?
The gross distribution. Yeah, so roughly $5,600.
Okay. And then plus the
Your
11.
Honor, I'm not gonna object to speculation unless there's some document from the 401k about how much there was a prepayment penalty. Then again, it's speculation and hearsay.
Well, Your Honor, I think it's in the code. Have you ever taken a distribution previously? Well, let me ask you this. Tell me what your job is. You do people's taxes,
I do that.
occasionally, right?
Let me rule on the objection. I'll sustain the objection that you may rephrase your question and see if you can get it, but it's not objectionable.
Via your knowledge as somebody who occasionally does taxes for individuals, is it a standard penalty of 10% when someone takes an early distribution from a qualified retirement account?
Yes, ma'am, from prior to retirement age.
And
There
what
were
is that age?
60, I think 62. It has moved. It has gradually gone up. Before the penalties, I think it's 62 now.
Are
Now,
there,
there was some provisions back in COVID. If you would have withdrawn your 401k or your IRA during the 2022 COVID outbreak, that they did waive those. And then they also allowed you to pay those, any kind of taxes over 3 years. You were given a 3-year window to be able to take care of the taxes also. That's the only difference I know of,
Okay.
as far as.
all right. Are you asking the court at a minimum to deduct the taxes that were withheld from this distribution prior to the splitting of the 401k?
Yes, ma'am.
Okay. But you're also asking the court to reduce that judgment to 0 based on the fact that you used it towards contributions to benefit the family. Is
Yes,
that
ma'am.
right? Okay. Your Honor, I'd move to mark this as the next marked exhibit.
$15.
Would your wife text you from time to time and just ask you for certain things or for you to do certain things, either for herself or primarily for the children?
Yes, ma'am.
And what do you have in front of you? What does this text message reflect?
It's asking for Hannah, who was playing soccer at the time, for me to run to Academy and buy some undershirts, long sleeve for Hannah and a little girl named Crystal, who also played soccer with Hannah.
And what's the date?
October 17th of 2022.
And did you agree to do so?
Yes, ma'am.
And during this point, you were not under any order of the court to do these kinds of things or make payments, were you?
No, ma'am.
All right. Your Honor, I'd move to mark that as presented. Sir, you haven't, I know your relationship with the girls have been strained. Have you been available to visit with the girls? Have you wanted to visit with the girls?
Yes, ma'am.
Okay. And have they visited with you some?
Some, yes. It's been a while, but they did. They have stopped by
Okay.
occasionally.
Okay. But again, you would have been available to visit with them.
Anytime.
And so in regards to, let's kind of go over what the final decree of divorce says. We've talked quite a bit about the retirement. The judgment, the child support judgment of $26,000, based on the $94,000 that you paid over the course of a year and a half, almost 2 years. Are you asking the court to reduce that to zero?
Yes, ma'am.
Okay. And then are you asking for, at a minimum, for you to pay half of your wife's uncovered bills and her to pay half?
Yes, ma'am.
And then in regards to child support payments subsequent to the entry of the final decree of divorce, are you asking to receive the proper insurance credit
Yes, ma'am.
and for the support to be recalculated based on such?
Yes.
And are you also asking to be awarded a certain number of days in the support calculation?
Yes, ma'am. That seemed like it would have been fair.
Okay. And would you actually like to have been awarded time with the girls?
Yeah. I mean, I
Okay.
still had time with them, but it was based on
Their discretion?
yes, ma'am.
Okay. All right. And would you also ask that if the court finds it appropriate to keep the child support judgment in place, the $26,016, are you asking for it to be recalculated with the insurance credit?
Yes, ma'am.
Okay, but again, be your position that it should be zero based on $94,000 paid.
Yes, ma'am.
Okay, now I want to switch gears for a minute to your personal property. Were you awarded your personal property in the divorce decree?
Yes, ma'am.
And it took a bit, but you finally got some of it. Is that right?
Yes, ma'am.
And I can find it. You've provided me with a list of what is still missing. Is that right?
Yes, ma'am.
See if I can find it. These are disregarded values of time. Those are values that you decide.
Yes, ma'am.
Your Honor, again, excuse, I apologize, got a stack of stuff. I'm entering an objection at this point in time to this line of questioning. The final decree states that the husband shall receive his personal property that remains at the marital residence. The wife shall be responsible for boxing up husband's items within 10 days, which include but are not limited to all his clothing, baseball cards, and other items and collectibles under the front porch. Husband shall have 30 days from the signing of this order to retrieve the said items and shall be declared to be abandoned, to have abandoned said items. If I could, Your Honor, when we the motion to retrieve this property was filed after we were in court in October. And the October order, again, that was signed, the motion to set aside the final decree is and shall be amended to be a motion to alter or amend as it relates to the following. One, the amount of money owed to the wife from the husband's retirement account, including but not limited to the funds withdrawn by the husband prior to the filing of divorce. Two, the amount of money owed to the wife mother for retroactive support calculated from the date the party's separation up to the date of the divorce. The amount shall be determined based upon the requirements of the child support guidelines, including but not limited to the party's income, cost of health insurance, the number of days each child resided with each parent. The husband, father may also request credit to offset for a marital debt payment he solely made during the time of the separation. Three, the amount of medical reimbursement owed to the husband of the wife. Four, the current child support owed by the husband. The amount shall be based upon the requirements of the child support guidelines, including but not limited to the party's income, cost of health insurance, the number of days the children resided, past tense, with the parent. And five, husband's ability to pay the monthly mortgage as well as the monthly payment due for the installation of the swimming pool at the marital residence. The granting of the divorce shall be effected as the date of the entry. The marital residence will continue to be listed for sale. And unless resolved by subsequent order, husband's 1/2 of the portion of all proceeds will be paid. That's the motion to alter amendment, Your Honor. And with all due respect, those are the only items that we're here on today. The issue on the provision of the final decree that I earlier read stating that he had 10 days or they shall be deemed abandoned is res judicata.
Your Honor, with all due respect, I'm not asking that that portion be amended, but he was denied the right to get his things. And when we were in court on the motion to set aside the final decree of divorce, we had discussed that fact and that he would be given a code to go in and get his things, because at that point in time, the house was on the market for sale. So we were supposed to be given a code to be able to go get his things. And we were never given a code. The code was requested several times. We were never provided it. And finally, we scheduled a time for Mr. Johnson to go meet Miss Johnson at the residence. She didn't show up, but instead sent their children to show up. And so he left. Then we were able to go back, I think the next day, Mr. Johnson was, and get part of his things. And then part of his things were delivered to my office, but we're not asking for that part to be amended. But he was denied an opportunity to go get his things, and he just wants his things that he was awarded.
Well, but Your Honor, again, none of that's been testified to.
Well,
I mean,
I'm
no
asking-
no disrespect, but none of that's been testified to yet.
I
And
think
the
you
issue of,
objected before she got to questioning about it.
well, because he's got some list with values. Again, and the issue being before the court is that they had filed a motion to retrieve, and that was what I was about to pull out, Your Honor. If I could, just 1 second.
Let's take a bit more in recess. We'll be in recess for about 15 minutes.
Thank you, Your Honor.
Okay.
All right. Okay, the 15 minutes.
You got your motion to retrieve. I'm sorry. Thank you. It's buried in here. Yeah.
At the time of the divorce, it went through a little bit over 2024.
Yeah.
There, and
But I
those
did
are
make a
reflected.
payment- I did make a payment in July
You made a payment in July
24.
of 24, but after that, from the time that the divorce was granted in April,
Mhm.
you made a couple of payments after that, I think, reflected on your Exhibit 3, I believe. Then after that, you made no payments.
Mhm.
And again, albeit the court order says that you were supposed to make those payments, you did not.
Yeah, I didn't have the ability.
And as a result of that, those accumulated and had to be paid off on them at the time of the closing.
Yes,
It wasn't the full amount. Some of it would have gone to interest, but your equity was depleted. It was a little bit less because you didn't make the payments.
yes, whatever the
Okay.
6 month difference was.
Again, on the $20,000 loan that you got on the 3rd of March of 2024, where did that money go? And again, I know you've invoked, I'm not trying to trick you. You know, on the fourth, on your Fifth Amendment privilege.
So that money, it wasn't the money. What they did is they took the payments that were missed and they put it in a partial claim, and that partial claim was recorded. So there was no money. It just took the payments that I missed, put them on the backside of the
Right. And again, the point, you didn't get cash and go spend it.
No,
You got it and paid on past payments.
yeah, I didn't get cash, period.
Okay.
They just did it themselves.
And that's where I'm getting confused is what did that, you took it and it paid the payments to the lake side, the primary mortgage or to the pool mortgage?
Lakeview did
Okay.
Lakeview did all of the paperwork.
It just went to the primary mortgage.
Yes,
But your records indicate that you were making those payments. So it was the payments from when you quit in 2023
free.
up to when?
So it was from, I think it was from October of 2023 till February of 24, maybe. Something like,
Okay.
I can't remember exactly. You would have to
So
take,
October, November, December, January, February, about 5 payments of how much were the payments?
$2,500.
So five times 2,000 would have been 20,000. I mean, again,
Or have been 10, but I think that they would have
yeah,
been,
well, with the $2,000,
yeah. Well,
$2,000 times 5.
it's 10,000.
Uh-huh. And that's what it went plus penalty. And again, it was a little bit
Interest.
different, penalties and interest. So that went for that amount of money that should have been paid after you left, but up until February, when the divorce wasn't granted until April.
Mhm.
And then after April, you didn't make any payments except 1 or 2.
Right.
And then that got pushed
Well,
on.
here's what happened is when that $20,000 was applied, that made the loan current.
At the time of the loan.
At the time, well, it made the loan current as of April of 24.
Right, you made it in March, so it brought it current as of that date.
Yes. Mhm.
And then the divorce was granted the next month.
In April of 24, right.
And that's when the order went down
That I
that
knew.
you were to make up all payments,
That were, yes,
which you did because you took the loan out.
right.
But you were also ordered to pay it post-divorce
Yes, ma'am.
until it sold.
Mhm.
And we've established you didn't make all those payments.
Right, I could not.
And you were ordered to pay the pool payment. You didn't make any payments on the pool after the divorce.
No. Mhm.
Actually, a little bit before the divorce, but after you were ordered to pay it.
Right.
You were voluntarily paying it before you were ordered.
Yes, yeah, and
After you were ordered, it was a court order saying pay, you don't have a choice. You understand that?
Mhm.
And that's when you didn't pay.
right,
And you moved out in 2022
yes.
and y'all used marital money and that was a discussion. You moved out to a motel.
Mhm.
You saw the separation was going to be longer.
Mhm.
You discussed it with your wife about getting an apartment, so you're not spending money at a motel,
Mhm.
and y'all furnished your apartment.
Yes, well, I furnished my apartment.
Well, again, with marital money. Y'all were still married. You spent money on furniture, TVs, things like that to put in your apartment.
Yes, ma'am. Okay, yes.
But you didn't, when Miss Salinas was questioning you about the division of assets on what your wife got, you conveniently forgot that you had all of that stuff. You had a bed.
I wasn't asked. She didn't ask me what I got. She asked me what Stephanie
Yes,
got.
what you got, she asked you about what kind of car you got.
Mhm. She asked me what I took from the house.
Okay. But again, in trying to justify why you might get some credit for something, you had an apartment full of furniture. You had a couch and a chair and a TV,
I had a couch and a love seat and a TV. Yeah,
couch and a love seat.
all my furniture when I paid for it was $2,100.
Okay. But when did y'all move in that house? No, I'm not asking. I'm just pointing to you. When did y'all move into that house?
In August of 2006.
And y'all bought furniture?
No, we already had some, but they subsequently bought some after.
But again, it's all used furniture that she got. Y'all raised 4 kids in that house.
Yes.
That's all.
Mr. Lannis?
You said the furniture that you purchased was $2,100.
Yes, ma'am.
Did you buy it used or new?
I bought it new.
What was it for 21?
The furniture that he bought, after he had moved out. All right. And did your wife know you were buying furniture?
Well, no, she didn't know I was going to, but I would assume she would have known because I had to go somewhere
You had to have something to sit on,
and
something
let's
to
lay my
sleep
bed
on.
down.
Okay. All right. And you said that you didn't have the ability to pay the house payment and the pool payment. At that point, let's say around April, May of 2024, what was your financial situation?
It was at that point, my eBay sales that I was doing to generate income had gone. They were very much depleted compared to the year before. And so at that time, I'm trying to pay the house note. I'm trying to pay the car note. I'm trying to pay my rent, my electricity, my internet. And I just couldn't, I could keep it all afloat.
Were you just getting deeper and deeper and deeper?
Well, that's why you see the payday things. I was taking out paydays to basically rush next week's check up to this week so I could take care of that. And groceries. And then I subsequently started having health issues and I had to deal with that too.
All right. And Mr. Johnson, you were paying those things when you weren't ordered to pay those, right?
Yes, ma'am.
If you could have paid those after being ordered to pay those, would you have?
Oh, absolutely. My credit is shot now.
I'm sorry,
Because of-
what?
My credit is shot now because of that.
Sure, sure. And your wife, well, and you don't know because you weren't here, but was she ordered? Did it appear she was ordered to pay anything in the final decree of divorce?
No, not anything that I got in black and white.
What debt would there have been as far as installment debt that the two of you would have had at the time of the divorce? You had the car payment for the Accord, right?
Mhm,
The pool payment,
mhm,
the house payment.
mhm.
Was there any other installment debt?
Not that I'm aware of.
Okay. So essentially, would it be accurate to say in the final decree of divorce, you were ordered to pay all the debt?
That you just mentioned, yes.
Okay. And the house, the marital residence, had it been recently refinanced prior to the divorce
Yes, ma'am. It was refinanced somewhere around December of 2021.
of 2021? And was it refinanced with a 30-year mortgage?
Yes, ma'am.
All right. So some 3 years later, there had been very little principal that was getting paid down than with that mortgage payment. Is that right? Okay. All right. Let me back up to your income. Now, when I asked you about your income, you haven't filed 22, 23, or
No, I
24
filed
yet.
22.
I'm sorry, you have filed 22?
Yeah, 22 has been filed.
Okay.
I was just never asked.
You have, okay, it wasn't asked for in discovery.
Mhm.
You haven't filed 23 or 24. And I think you said in 23, you had a $72,000 loss,
78.
$78,000 loss. So when your return is prepared, ultimately, your income is going to be far lower than what your W-2 income reflects. Is that true?
It'll be negative.
It'll be what?
Negative.
Just gonna interpose an objection. Again, that may be true, but what we're just dealing with is for child support purposes, and there's certain things that, again, just because he takes a paper loss, depreciation and paper losses are not necessarily
Well,
reflected on income.
and I understand, but there was an inference that he was basically lying about his income. And so taking the totality of the circumstances.
Overrule the objection.
So again, sir, if you look at those losses ultimately and your actual income from your primary job, could it be that your income was far less per month than what was stated in the final decree of divorce?
Yes, ma'am.
Okay. And would that be similar for 2024?
2024 last year, it wouldn't have been as bad.
Okay.
Because my sales basically, they dipped really badly. And so I wasn't selling stuff at a loss. And then I got a small increase at work. And so I probably would have broke even on my eBay sales in 2024, right
Okay.
at maybe made about $1,000. So yeah, in 2024, my income is going to be considerably higher than 2023.
than 2023 when you had the $78,000 loss.
Yeah.
Okay, but again, at this point in time, you really don't know for certain
No.
until you have that prepared, right?
I still
All
have
right.
October to do that.
All right. And in retrospect, now going forward, have you maybe come to the conclusion that maybe eBay, baseball cards, those types of things aren't what you thought that they would be?
Yeah, I don't do that. I mean, it's very rare. I think I've made, in 2025, I'm going to say I've made 11 sales total.
Okay. Now, you were asked about some incidences, and I think the second one was with Community Bank and a check kiting scheme. That was in 2012,
Yes.
and we're now in 2025.
Mhm.
You bank with First Federal, is that right?
Yes, ma'am.
And-
Yes.
And in
First
full-
Financial.
First Financial, sorry, and we've, in full transparency, those records have been produced.
Yes, ma'am.
And
And I don't write checks anymore. Just for the record.
all right,
I don't
well, I
write checks,
think
period.
I've seen some maybe where you're writing cash to yourself, where you're getting some money.
Oh,
in.
the little
Yeah.
ones they have at the
Mhm.
teller line. But
All
they
right.
write those out.
Now, in regards to the things that you, let's go back to you getting your stuff from the marital residence, your personal property. You were asked a lot about December 7th, the 8th, and maybe the 9th. Initially, did I instruct you to bring a civil assist with you? Was that requested?
Yes.
Okay, all right, and you did that.
Yes, ma'am.
And you went to get your stuff, and your understanding is that it had been worked out that your wife was going to be present. And so when she wasn't, and your daughters were there,
Yes, ma'am.
did that concern you?
On a couple of fronts, it did concern me. The first thing that concerned me is my children are there thinking, they got to see me with a cop. They got
Sure,
to see me with a cop there.
sure,
And then my second concern was, what if something happens to this house and nobody's here to say, oh, well, he did it for sure. I did not feel comfortable being around there.
sure. And so you left, is that right?
Yes, within 2 minutes.
All right, and you called me, is that correct?
Very angry. I
Okay.
did.
And ultimately, it was worked out where you could go back and get your stuff the next day.
Yes, ma'am. I was told that I could go get it anytime I wanted to.
Okay, and I want to be very clear, because there was a lot of back and forth. Tell the court what happened the next day.
So I'll go to my dad's. He's going to go with me because you requested I take a witness.
Sure,
And I took my dad because I didn't know if the neighbor was going to be there. So I get there, I walk over, and Robert, who is the neighbor, is there. So I said, hey, man, you just mind if you come over here and watch me? I got to get some stuff off the back porch to make sure I don't knock out the lights or bust windows or do anything, bad. He's like, sure, come on. And so I started loading the stuff into my dad's truck. And and this time I can't remember, it's maybe an hour later, Stephanie showed up unannounced. And at that point, there was no civil standby. There was no nothing with there. And I was like, I don't like this. I don't like her just showing up because then it's her word against mine. And so I just left at that point. I left whatever was left on the porch there. And Robert told me, he said, hey, I'll make sure nobody messes with it. And I left.
okay. And then you came back the next day?
The
Is
next
that
day,
right?
and late at night, I
Okay.
came back. I actually had a civil standby that night. He
Okay,
came with me. He sat in the driveway and I carried my friend Preston. Preston came with me to help me get the rest of the stuff.
okay,
Again, I could still see stuff of mine in the garage that I couldn't get out.
okay. And then ultimately, later, after the motion was filed to have your stuff returned, you did in fact receive some things that were brought to my office.
Yes, ma'am.
Is that right?
Yes, ma'am.
Okay. And the list that we provided to the court today with the highlighted area, that is an accurate list of what you feel is still missing from what you feel you should have been awarded.
To the
Is
best
that
of my
right?
recollection.
Okay. All right. And are you simply asking for those things to be returned to you?
Yes, ma'am.
Okay. Now, what happens if the class ring, if let's say it stayed at the house? I mean, you understand that there may be some of those things that just don't exist anymore.
I do understand that. And it's completely disappointing, especially for my class ring from 1988.
Sure. All right. And you're not asking for example, you're not asking to be credited dollar for dollar what you've paid
No.
since the separation, correct?
No,
Are you asking for there to be some consideration in regards to the calculation of the child support arrearage?
for the credits for health insurance, yes.
And do you believe, is it your position that from the date of separation through the date of divorce, that you have contributed financially to the family,
Absolutely.
not only to your wife, but to your daughters?
Yes, they wouldn't have had a place to live.
And are you asking for the court to now take that into consideration? As child support was ordered all the way back to the date of separation, is that right?
Right. And I just didn't think that was fair considering what I had paid.
Right. You paid $94,000.
And they told me about $26,000 in arrearage.
Yes.
So
So,
if I would have just paid what I was told to pay, I would be up 70 grand.
right. You had no obligation to pay those things that you did. And then you're asking, as far as the Vanguard account, you're asking at a minimum that there be some consideration with the taxes that were withheld from the monies, right?
Yes, ma'am, not based it on the gross, based it on the net.
Okay. And then you're asking also for those medical bills to be divided, your wife's medical bills, not the children. Let me ask you, that brings me to a question about the HSA. The money that was put into the health savings accounts, those were monies that were deducted from your income, right?
Mhm.
So if you made $1,000 and there was $100 deposited into the HSA, that was from your $1,000, correct? That wasn't from an employer contributing on your behalf.
They used to do that. They used to
Okay.
give us a small stipend early in the policy period.
Okay,
Mitchell cut that out
okay.
along with bonuses.
So all of those monies that went into that account were from your earnings?
Yes, ma'am.
Which were marital. I mean, you earned those during your marriage. Your wife had earnings during your marriage as well, right?
Yes, ma'am.
And your wife wasn't contributing towards any of your expenses, was she?
No,
Okay. And then I want to clarify that 2250, that was from a 2021 tax refund.
yes, ma'am.
And that was paid by agreement between you and your wife. Okay. Now, when your house sold, and again, you bought your house in 2006?
We built it in 2006.
You built it in 2006. All right. So, and I think you said you made all the payments on the house. Okay. And you cut the grass and you helped maintain it and those things. And it was sold in 2025, this year in January. And your wife received half of those proceeds. Is that right?
Mhm.
Okay. How many dollars of those proceeds that were realized from the sale have you received?
None.
None. All right. And you're asking the court to release these funds that are being held by the court right now, to you. Is
Yes.
that right?
Yes, ma'am.
Okay. Or at least, of course, whatever the court determines is equitable, but is zero equitable?
No,
And that's what you have right now.
I have zero.
That's all.
Mr. Roberts, any recross?
Yes, Your Honor, just briefly, if I could from here, you just testified again under oath that she contributed to none of your expenses.
Since I've been moved out of the house, no,
Who paid your automobile insurance?
except for the, oh, okay. I
Who
missed-
paid your cell phone bill?
My supplement has been canceled.
When?
I don't know. I was just.
I thought you, did you call, I thought you were standing up. She paid the cell phone, didn't she?
Yes, up until whenever it was cut off.
Until it was cut off. So she did, so again, she contributed to your expenses,
Some,
correct?
small amount, yes.
And y'all put in March. When did you leave?
April of 22.
Okay, and before that, y'all had purchased another vehicle, the Charger.
Hold on a second.
I'm not really sure.
You leave let's just pause for a second because Ms. Pam Jenkins, our clerk, has to leave, and this is her final day. And I would just like to recognize her for all of her years of service to Cheatham County and welcome Ms. Rhonda Vaughn, the new clerk and master. So Ms. Jenkins, we were gonna have a big celebration and cake, but these two lawyers have gone on so long that we just have to cancel that.
Well, Judge, my whole purpose today was for her to understand that she had no regrets for retiring. That if she had to put up with me on her last day, then she would be, this is the best decision I've ever made.
That has been well established. All right. Thank you for letting me interrupt because I knew she had to leave to go somewhere else, and I just wanted to not let it pass without letting the whole world know and recognize her contributions to Cheatham County and to the 23rd Judicial District as a whole. And I've tried cases in this court long before I became a judge, and she has always been helpful and courteous and nice, even when perhaps we didn't deserve it. So thank you again. All right.
Thank you.
Good luck.
And again, all four of the kids that who were adults and minors were still living in the house when you left.
Yes,
And you paid a fixed amount and she had to pay everything else.
yes,
And then you neglected to pay anything for a significant period of time for the kids as far as child support was concerned. You paid what you wanted to do.
what I could, what I was able to.
Well, you
If
paid
I-
the house payment for a period of
If
time,
I could have, I would have paid it.
but somebody had to cover the rest of it. She did it, didn't she?
I guess.
That's all.
Redirect.
The adult children, right now there are 3 adult children, right? They're all over the age of 8.
All four of them.
All four, yes, all 4. Are they working as far as you know?
Yes, ma'am. As far as
Okay.
I know, all of them.
And
One of them is married.
okay, and so there's only 3 that are still single. Do you know how many live in the home with your wife?
I'm gonna say 2. I don't know if Kayla's living there or not.
Okay,
I don't have any idea where they live, so.
that's all here.
Nothing further, Your Honor.
That's
All right.
approved.
Thank you, sir. You may step down. Ms. Salinas, you may call your next witness.
Your Honor, that's our proof.
The defendant has rested his proof. You wish to put on any proof, Ms. Roberts?
Well, Your Honor, I do I first request that the court, enter a judgment just ratifying the final decree and the amounts owed under the final decree. I don't think they've met their burden on the issue of a motion to alter or amend. There has not been any fraud perpetrated. There hasn't been any inappropriate, if things that are brought forward. There's not a mistake of law or fact that has been produced. If the mistake of fact would be that his child support is less than what it should be. There's just not been a showing that in the manifest, that there's any type of manifest injustice that is happening. As set forth in the final decree, he owes her 1/2 of the Vanguard account. He cashed it out over three series of what we see. He cashed it out. It's something that my client was entitled to. He cashed it out, and she's entitled to it, asking for it to be relieved of that judgment, and then to be given credit towards that judgment for these payments. I don't think they've met their burden. The medical expenses, he testified unequivocally. I didn't even cross-examine. One of the few things I didn't. He canceled it. It was a sign-up period. I didn't sign her back up, and I didn't tell her. And then the retroactive support obligation of the 26,000, again, Your Honor, is the final question he did. He paid us some certain amount of money. He didn't pay child support during the time of the separation. It's not questioned. He paid some payments, but my client paid the remainder. His was a fixed amount, but from a child support payment, he never disputed that he didn't pay it. He testified that he only made 3 payments since the divorce was entered at $775. His income has significantly increased. And again, he didn't bring any proof. Had it not been for me on cross-examination putting his income in, there would be no proof as to what his income actually was in 2024. And as a result, and he still hasn't prepared his taxes or brought in any of the supporting documentation. And we've shown he has significantly more income coming in. He may have deductions, but he didn't bring them and show them. The post-judgment debt of $20,125.54. Obviously, Your Honor, he took his Fifth Amendment privilege. She should be able to collect that. So based on that, Your Honor, I mean, the total amount of the judgment of what is in the court order, he owes her $85,617.28. There's not sufficient money in the court to pay that. So we would request that their motion be respectfully denied and that the judgment stand and that the $78,000 be paid out to her. Of course, we'll have to collect the difference. And again, I will put on some proof as far as the property is concerned.
Well, let me just say this, that I have already determined that based upon the volume of exhibits that we have exhibited in this case and the testimony that has taken place both on direct and cross-examination, that it was going to be necessary for me to analyze this more fully by taking the matter under advisement. So, Ms. Roberts, I'll simply reserve ruling on your motion until I have an opportunity to more fully digest all of these things. And I would again point out that I'm not the one who issued this default judgment divorce decree that encapsulated all of these items, nor am I the judge who heard the motion to, in October, I guess it was, when you came back before Judge Turnbow, and he put an order down that treated it as a motion to alter or amend. Clearly, I want to also consult the case law that's regarding motions to alter or amend as to the standard that's required for an to alter or amend. It is discretionary with the court. I do know that to be a fact, but there is obviously certain standards. There are certain standards that have to be met. And for that reason, to be fair to both of these parties, I think it's incumbent upon me to take it under advisement. Now I can give you a court date to come back and we can, I can announce my ruling if that's what you wish to do.
And Your Honor, if I may just.
Come to the podium. Ms. Roberts, I can hear without much of a enhancement, but Ms. Salinas, if you will come to the podium, I would appreciate it.
It's the order that we entered in October of last year. The order sets that the motion to set aside the final decree is and shall be amended to a motion to alter.
Judge Turnbow, right?
That's correct. Well, we had actually we reached an agreement and made an announcement. So he didn't hear proof, but he did sign the order. And it says that the motion to set that aside would be amended to a motion to alter or amend as it relates to the following: the amount of money owed to the wife from the husband's retirement account, including but not limited to the funds withdrawn by the husband prior to the filing of the divorce matter. And number two, the amount of money owed to the wife, mother, of retroactive support calculated from the date of the party's separation up to the date of divorce.
I normally would be fine with you reading through that, but I've read through that.
Sure.
And I'm familiar with what the provisions are of that, and I have it before me in the court file. So unless there's something you can add to it, just simply reciting what's in that order, please feel free to expound on how you think that impacts.
Well, I think how it impacts Ms. Roberts' legal argument is that it was agreed and it was made in order that those specific items would be brought before the court, and the court would determine then if it was appropriate for there to be any offsets granted against or to those judgments in favor of the husband.
So your interpretation, if I'm understanding you correctly, is that the entry of that order more or less changed the standard for altering and amending an order, but by saying these issues will be reserved for the court to make a determination.
That would be correct, Your Honor. That would be.
I'll consider that argument when I make my ruling.
Thank you, Your Honor.
Your Honor, if I could, just one clarification on what Ms. Salinas said. When we were here in October, that's when I advised Ms. Salinas that her client had filed bankruptcy.
That is correct.
And we could not go forward because there was an automatic stay had gone into effect, and I got notice through my client that there was an automatic stay. So we could do no financial issues, and so that's important on what Ms. Salinas what the interpretation, as it said, finding that the announcement in keeping with the best interest, the motion to set aside is and shall be amended to a motion to alter or amend as it relates to just these issues. And they had a right to put on that proof. But again, they still have to prove, again, what Your Honor said, and I won't belabor the point, but I did want to make sure you understood. We could not go forward in front of Judge Turnbow. And only after that happened did we, dealing with the closing agent, were we able to get the bankruptcy dismissed because we weren't going to be able to sell the house, which was going to put a whole nother
All
turn
right,
on this.
well, as I said, I think it's incumbent upon me the two of you have been dealing with this case for a long time. This is the first time I've touched the case. I want to make sure that I'm treating both sides fairly in making the rulings. So I want to review all of the documentation and exhibits that have been done, as well as the prior rulings of the court. And then I will also look at the case law. If either one of you want to supplement submitting any case law on the standard for a motion to alter or amend, then I'm happy to do that.
So I want to put on my proof as though you denied my motion so that it's in the record. Is that correct?
Yes,
Your Honor, I'm calling.
all right. Raise your right hand.
Ms. Johnson, you filed for divorce in this court with Ms. Rhonda Crabtree back, I think, was it October of 2023? Or sometime
October is correct.
of 2023, correct? Had you and your husband been separated since April of 2022?
That's correct.
What was the basis on why you filed for divorce? Was your husband soliciting prostitutes?
Yes,
Okay. And you filed and were granted divorce on the grounds of inappropriate marital conduct. Is that correct?
yes.
Y'all had lived separate and apart, and at the beginning, was there an attempt when y'all separated? Was it, I'm done with you? Or was it, let's see if we can work on our marriage?
I think for the most part, we tried to be cordial for the children for a few months, and yeah, that was about.
Well, you heard his testimony saying that he moved into a motel because he didn't know how long the separation would last, and then y'all discussed, and he moved into an apartment, and he still didn't know what was going to go on, whether y'all were going to reconcile or not.
Yes,
Okay.
I did know he moved into an apartment until after the fact.
Okay.
It was a while before I knew.
Okay. Now, as far as you going to court and asking for the relief that you sought, had you received regular and routine payments from him from the time of the separation?
No,
You don't dispute that he began paying the mortgage, is that correct?
I'm sorry.
He had been paying the mortgage,
Yes, he always had. Mhm.
and that at time that had always come out of his account.
That is correct.
You heard his testimony, and when I questioned him, that you no longer agreed to do a joint checking account with him back in 2012 when he got with the check kiting scheme going on. Is that correct?
Mm-hmm.
Okay. And so he'd had his money and you'd had your money. Is that right?
Yes.
Were there certain, during the course of the marriage, did y'all, as most couples, divide out, I'm paying this and you're paying that?
Yes.
As part of that, what was your obligation during the course of the marriage and that leached into the separation?
Yeah, I paid all the utilities at the home. I paid everybody's car insurance. I paid everybody's cell phones. I paid groceries. I paid most of what the children needed as far as clothes, school, things like that.
School fees when they had to come in at the beginning, workbook fees, lunch money.
Yeah, they took their lunch, but groceries did take their
Well,
lunch,
but
yes,
again,
yes.
that if they
Yes.
had something, you know, going to ball games, paying for snacks at ball games,
Yes.
all things like that.
Mhm.
And so what go ahead.
In March of 2022, it wasn't it was in my name only. It was a Dodge Challenger. I also paid that payment.
Okay.
And I was awarded that vehicle, but I did pay that payment as well.
Was that just something you just willy-nilly went out and bought, or did y'all go out and look and buy a car?
For sure, we were together.
Okay, so y'all were together, so y'all purchased a car and you made a car payment.
Mhm.
You had previously driven a car that was in his name, but it was purchased during the marriage. Is that correct?
Yes.
And at what point in time did that car get transferred over to one of your daughters? When you
She,
bought the one in March?
yeah, she turned 16 and she got the car.
Okay. And at some point in time, that car was paid off?
So we were told that, but the car was totaled and we found out that it wasn't paid off, that we had been told that it was.
Okay. And what happened to that check?
That check went to me.
Okay. Okay. And was it made to was it jointly made?
No, it was to me. I paid the car insurance, so it came to me.
Okay. The check was in your name?
Yes, it was.
Okay. Did you ever forge his name?
No.
The check wasn't bought jointly to you
No.
but joint and you deposited into your account or anything like that? If he makes accusations that you forged his name all the time, would that be true?
No.
Okay. Now,
And I'm going to make a correction. I think on the car, the car that was totaled, that went directly to my checking account.
you're wanting a check.
There was no check. There was no check. The check was the overage in the escrow or whatever was sent to me, and that was in my name only. No, nothing was in his name and my name.
But you paid the automobile insurance for his and all the kids'
Yeah.
cars.
Yes, that is
And
correct.
when that car was totaled,
They sent the overage to me and I made him aware via text.
and the overage, you mean just the difference between what was owed on the car and the equity and the
Yes,
payoff or the value of the car. Is that correct?
yes.
And you used that. Did you, who maintained the yard after he left?
I did.
You mowed it,
Yes,
put gas in
yes.
so you expended as much or more on the family during that period of time. Did you seek at the time of the divorce retroactive spousal support from him?
No.
When you went and introduced evidence, at the court as to his income, what was the last indication of what he made?
It was a W-2 from the last time that I had any information of what he made.
Okay. And so you didn't try to increase his income?
No, it was actually like 76,000, I think, on that one. And
No.
Yeah.
So actually, when you did the math, it was actually a little bit less.
Yes,
Is
it
that
was.
correct?
yeah,
Did he provide you, or did you have any way of obtaining how much health insurance it was?
no. No, I had no way.
Okay. During the time that when did you learn that he was served with a divorce complaint? Was there ever discussion between y'all and saying, why are you divorcing me? I can't believe you're doing this.
No, not that I remember.
So
No.
you don't even know when he was served or what was going on?
Mm-mm.
No discussion whatsoever?
No.
Okay. So y'all weren't just, when you said earlier, when he left, we were just kind of trying to get along for the kids.
Yeah, no, that was not that point. And we were past that when.
That was in 2022 earlier. And then after that, where were y'all communicating, doing anything, knowing what was going on?
We would communicate via text, but that was about it.
Okay. Sure, I think I've given you one of these. I'm going to show you just a little synopsis to assist in your testimony. Pursuant to the final decree, he was ordered to pay you one half of the Vanguard account.
That's correct.
When did you learn that the Vanguard account had been depleted?
When the W or the 1099s or whatever you get from that, I received, because his address was still the marital address. The
Okay.
tax paperwork came to the
Okay.
home.
And you're just asking for half of what the account was.
That's
It's been entered, the 1099 has been introduced. Is that
Mhm.
correct?
That's correct.
And and again, I can pull and get, but I don't know that it's necessary. You were listed as the beneficiary as of that 401k had something happened to him. Is that correct?
I am not aware of that.
Okay.
I do not know.
And did he notify you as his spouse at the time that he was cashing this out?
No, he did not.
And he did that in 2022?
Yeah.
Do you know did y'all receive a refund in 2022? Or he said he filed married filing separately, or did y'all file jointly in 2022?
In 2022 would have been 2021's taxes, and yes, we got a refund.
Okay, no.
Oh,
For the tax year of 2020, he cashed out the retirement account in the tax year, the calendar year of 2022.
no, I did not file taxes with him in 2022.
Those taxes would not have had to been filed till 2023.
No, we were.
Did y'all file taxes together on your income in 2022?
No,
He would have gotten the 1099, and you heard him testify that he got a refund. Did he share that with you?
no,
Okay. And did you know that he had cashed at the time? You didn't learn about him cashing it out until after it had been done,
that's
correct?
correct, that's correct.
And you simply asked not for for him doing it, anything, you just simply asked for half of that.
That's correct.
During the course of your marriage, were you the primary breadwinner for the early part of your marriage?
No,
What did y'all do? Were you a stay-at-home mother for a period of time?
yes,
And then when did you go into the workforce?
2014,
And is that when you went back to school in 2010?
yes,
And what type of school did you go to?
I went to nursing school.
Okay, did you go to a traditional college or a junior college?
No, I
What?
went to Austin P.
Okay, so you got a 4-year
I
degree
did, mm-hmm,
and you got your BSN,
I do,
and that took 4 years.
yes,
And you-
longer, actually, I think, maybe I was taking classes one at a time before that, but
Okay.
yes,
So you got your BSN in 2014 and you went to work, is that
yeah,
correct?
that's correct. I did work through nursing school as well, just like on the weekends, like as a
Okay,
tech,
okay.
but no, I was not working full time.
Okay. And so he was the primary breadwinner. So from 98 when y'all married, up and until the time that you went in the workforce, were you able to save or develop a retirement account or anything like that?
I did, early in the marriage work at, credit union as a clerk, but that was before we had children. Once we had children, I worked maybe 6 months and then I was home with
Okay.
the children.
But during that period of time, you were not in the workforce, so you were not paying into Social Security, correct?
No,
You did not have a retirement account
no,
during the major part of your adulthood until 2014. And this money would have been earned during your marriage
that's correct.
and would have been set aside to assist you when you turn 65 or whenever you're able to retire. Is that correct?
Yeah.
Okay. Now, medical expenses, let's talk about those.
Okay.
Who kept, because you were a stay-at-home mom and you only went to work in 2014, did you have insurance available to you when you went to work?
When I was a tech during nursing school, no, because I was just PRN.
Uh-huh.
He's always had my health insurance,
Okay.
always.
When did you discover that, was there any discussion after the separation or anything of saying, hey, I'll get my own insurance?
No,
You heard him testify that he had an open enrollment and he just didn't re-enroll you and didn't tell you about it.
yeah, no, I found out when I went to get prescriptions filled that I had no insurance.
And then shortly after that, did you have a medical emergency that resulted you in the emergency room?
I did.
When you found out, would you have found out that he canceled the insurance,
It was in November of
in
2023.
November 2nd of 2023 when you went to get a prescription filled?
Uh-huh.
Shortly after that, when you found out you had no insurance, did you immediately go to your employer to sign up?
Yes, and I had a very limited, it actually was our open enrollment. I had like 5 days to sign up, but I did sign up, but it did not go into effect until January of 2024. So
So-
I went
And
at
so,
least 2 months without insurance.
and you had a medical emergency in
December.
December
Mhm.
5th and had to end up in the emergency room. Is that
Mhm.
correct?
Correct.
And you incurred debts on that.
Yes, I did.
And again, you heard him testify that the employee family was the same amount regardless of how many people were on it.
Mhm.
So based on that, was there some financial windfall he got by knocking you off of it? Based on what his testimony was, he was
Not that
paying
I'm
the
aware.
same?
Not that I'm aware of.
So you want those medical bills paid and the court saw fit to do that, is that correct?
Yes,
And have those been paid?
yes,
Who paid them?
I did.
So that's money to reimburse you.
Yeah.
When you got those, was it affecting your credit? Did it get turned over to collections?
No,
You just,
I've made payments on them and paid them.
now, did you have the money just to pay it all at one
No,
time?
no, made payments on them.
Okay. So that was a debt that was incurred during the marriage for a medical necessity, and you paid that,
Yes.
correct?
Mhm.
Okay. Now, the retroactive support, let's talk about that.
Okay.
Did you, with the assistance of the Child Support Receiving Agency, Miss April Miller,
Mhm.
sit down and run the guidelines?
Yes, we did.
And do you recall what incomes you used in getting those all the way back to the date of separation?
I believe it was 6,500 for me and 6,250 for him.
And was 6,500 your income?
Yeah, yes.
And again, did he have any overnight visitation or any significant time
No.
with the children? And you had a lesser amount, and now we found out you used a lesser amount than what he actually earned. Is that
Mhm.
correct?
That was the last thing that we had was W-2.
Okay.
I think that she can testify to that. I don't think she knows what he actually earns.
Well, based on what we've heard today.
Yes.
I'll qualify. Based on the testimony of the documents we put in today, his 2022 income would have resulted in higher income. His 2023 was 80,000, his 2024, 88,000, I believe.
Yeah.
So that's higher than what you calculated it on. Is that correct?
Yeah, we were basing it off of 76 and they just said, let's do 75.
Okay. And again, you only had the time that you're looking retroactive support. You didn't seek assistance for your adult children, even though they were still in the home.
Mm-mm.
Were you assisting your adult children
They lived in the home, yeah.
using gas, water, and electric,
Mhm.
eating food? Were you providing them with cars and gas money?
To object
I'll-
to the relevance of supporting adult children. She has no obligation to.
I'm
do
sorry,
that.
what?
For the relevance of her supporting adult children.
I will take that stipulation and ask that you strike all of the payments made for the adult children. The Tennessee Tech payment that was for an adult child, the Venmo payments to the adult children.
I'm gonna let them both testify about the support they've made.
So you were,
Mr. Johnson testified about those matters as an example of family support that he wants to have credit for. So she's entitled to testify about her own contributions
Mhm.
to offset what he may say he did.
Yes, Your Honor.
So you were providing for their everyday needs. Is that correct?
Yes.
Not just an incidental payment here or there?
No,
But you weren't seeking support for your adult children in this.
no,
Did you seek a retroactive modification for family support?
no.
And during the period of time that he was doing that, he was for a period of time, for about a year, he was paying the mortgage payment.
That's correct.
Is that correct? He paid the pool payment for a shorter period. Is that correct?
I was unable, my name was not on the house note, so I was unable to find out, but I started, yes.
Was your name on the pool note?
Yes, it was.
But did you receive, so you didn't go back and ask for retro support on that, and you don't believe he's entitled to credit for any of those payments? Did you pay as much or more than what he did?
Yeah, yes,
Now, again, you think these child support calculations are fair?
yes.
And of that 26,016, has he paid anything?
No,
And based on, and you had, at the time of the divorce, you only had one child at home, is that correct?
at the time of divorce,
April of 2024,
no,
it was-
Megan was still.
was she a minor?
Yes,
Okay, because again, in the child support calculator, in the order, there's only one minor child listed.
Megan turned 18 in 2023, 2024.
Okay, yeah.
I don't know if their birthdates are on there, but
Well, again, if we're looking at the order, and I can
Okay.
pass it to you, you calculated the parenting plan has one child, LBJ,
okay,
and that's y'all's youngest child.
okay,
And it's based child support only on one child.
okay. The current support.
The
Yes.
current, that's what I'm talking about,
Yes.
current support now.
Yes,
Retroactive was only for two children. But by the time y'all went to court, you calculated child support for one child at $775.
and the retroactive was also including 3 children for a short time and then 2 children and then current for 1
It
child.
was one child.
Mhm.
And you have given him, and we have stated from the beginning that he's made 3 child support payments. And the last payment he should have made was June of 2025. Is that correct?
That's correct. She just turned 18
Mm.
last week.
And so from April of 2024 to June of 2025, that was 15 months. Is that correct?
Yes,
And so he should have paid you $11,625. Is that correct?
yeah,
And given him credit for basically the 6 payments he made. He owes current support of $6,975. Is that right?
yes.
Did you sign to borrow $20,000 on the house?
No, it did not.
I want to show you Exhibit 23. Well, you've seen Exhibit 23. Was that your signature?
No, it was not.
Did you ever appear before his aunt to sign that?
No, it did not.
Did you ever acknowledge or give her permission to notarize your signature?
No, it did not.
Does it even match your signature?
No, it does not.
When did you discover that there was a secondary loan taken out without your permission?
That's not what she was looking for. She was looking for the deed of trust, that's all.
I'm sorry, that's a
She's
huge,
already moved on.
yeah, she's acknowledged it. I don't think there's a need.
The record will reflect that she's acknowledged that is not her signature that appears on the mortgage deed of trust.
When did you find out about that?
I'm going to say it was before we went back to court in October. Maybe May or June. I'm not really sure I'm not really sure.
Post-divorce, post-filing of
Oh, yes.
his motion to set aside the final decree,
Yes.
correct?
Yes.
And you saw on that where it said that you were not responsible for that, that whoever forged it acknowledged on there that you weren't responsible for any of that obligation, and you're asking for that to be paid back out of his half.
That's correct.
You're not asking for half because you didn't incur that debt.
That's correct.
Okay. So all of those, and again, did you go through your books and records and give him credit for $4,157.50 in payments that he made extra?
I'm willing to. He did pay some in groceries, several weeks, in 2022.
Right, like on that list that he produced where he had given Venmo Stephanie,
Yes,
Venmo
yes.
Stephanie, Venmo Stephanie.
Yes,
You went through those and looked at that, and you agreed that he assisted you when you
Yes.
were short and do
Yes.
things to the tune of $4,157.50. Is that correct?
that is correct.
And you were willing to give him credit for that towards those judgments?
Yeah.
And additionally, you received a refund when the house sold. The homeowner's insurance was just in your name. Is that correct?
That's correct.
And did you receive a refund for that?
Yeah.
And the total refund was $3,960.63. Is that correct?
Yes, well, to alter that, it was in both of our names, but I was the primary. I've always had the insurance, and so that's how they cut the check.
And
It
you-
was a check, and it was made out to me only.
You only, because you were
Yes.
in possession of the home,
Yes,
and you deposited those funds.
yes,
And you acknowledged that he should be given credit for half of those,
sure.
because again, it was a marital debt.
Yes,
So given credit for and that's $1,980.31. Is that correct?
yes,
Minus the 4,187. So do you believe that he has owed you $79,477.78?
yes,
And total judgment, $85,615.28, minus one half of the insurance refund at $1,980.31, minus the credit for those Venmo payments of $4,157.50, leaves him owing her $79,477.78. Okay. Now, you acknowledge, do you not, that he was ordered under that decree to make the mortgage payment and the pool payment up and until the time that it was sold?
that's correct.
He did not make those payments.
No,
We're paying the judgments that are paid and the back child support, the current child support arrearage, as well as that $20,000 fraudulent payment the mortgage that he put on. In addition to that, he missed payments that resulted in you having less equity. Is that correct?
yes.
Were there penalties and interest? Did it actually go into foreclosure and attorneys get involved?
On the house, I do not think so. I think it went into default.
It went into default.
I got several letters. They were showing up at our home, leaving notes on the door. I could not get any information because my name was not on the loan. So I just know what was showing up at my house.
Mhm.
So I'm not sure exactly how far it got past due.
But it was significant.
Yes, and the swimming pool, it was about to go to litigation. I do know that.
Mhm. But again, to be in all candor and what we're doing, when the divorce decree went down, the marital residence, in looking at it, it stated the marital residence will be sold and the proceeds divided equally between the parties. And it does say in there, until the marital residence hold, the husband shall solely responsible for the indebtedness on the residence and the pool, and he would indemnify and hold you harmless from those.
That's correct.
Those have affected your credit, have they not? Expect the pool.
Yes, yes, it did.
And you have lost percentage points on your credit
Yes.
because he failed to pay it.
That's correct.
No real way to quantify how much that is,
Right.
and you're not asking necessarily for a money judgment, but is that a reason why the court should not grant him any credit
Yes.
in addition to all the other payments that you have made? Now, let's go on, if we could, ma'am, to this list of personal property. He was ordered pursuant to the decree to come with, you were ordered to pack up his belongings. Did you do that?
I did.
And where did you place them?
They were in random places in the home in boxes
Okay.
since April. His closet was packed up. He left the whole closet. There was clothes in his closet. So
Okay.
yeah, that was packed up in April, and that we had discussed it and he was going to come in April, and then he said, no, it's going to rain. I'll come back. I'm not sure his exact verbiage, but he never got back with me.
So you heard him testify that he got the final decree handed to him from his mail lady
Yes.
about 3 weeks after the order was entered. He thought the order was entered in April, the 1st of April, and he said he got it towards the end of April.
Okay.
And then after that, he contacted you, did he? Or you contacted him about picking
He
the
was
stuff
supposed
up?
to come April 28th or 27th. So it was not even, it was within the 30 days.
Right. So he would have had to receive the final decree sometime, if y'all had arranged the 21st or the 27th, he would have had the decree before then.
That's correct.
And did y'all plan a date for him to get it?
We did.
And who canceled that date?
He did.
Why?
He said it was supposed to rain.
Okay, did he request an alternate date?
I just said, I'm not going to put your things out there until you tell me you're coming, because he said, just put them out on the porch. I don't want to come get them when y'all are there. So I said, I'm not going to put your things out there until you tell me you're coming. And that was it. I never heard from him
Okay,
again.
and then you heard him testify that until he got Miss Salinas involved in it, he never asked again.
That's correct.
Okay, and we got a request to get that after we were in court in October. Is that correct? We discussed it in the court in October.
Yes.
Did you ever, you understand we had emails back and forth between Miss Salinas and I where he just wanted to come in the house and go through the house.
Yes.
Was that ever an agreement that you consented to?
No. When the first agreement in April, he said he did not want to come when we were there, just put his stuff outside on the porch.
And you took him at his word?
Yes.
And did you do that?
I did not. He canceled, and I said, let me know when you're coming. I'm not putting your stuff out there until you tell me you're coming.
Okay, and so through all of the stuff that was going on in this case, at some point in time did y'all agree on to pick a date for him to come?
After the April date?
Yeah, after the very first time,
Right.
after Miss Salinas and I got involved
yes.
in it. Did we pick a date for him to come? And that would have been in
December.
December.
Yes. Mm-hmm.
prior to, and he had been to the house, and I think I asked him in March of 23 and September of 23,
That's
he had been
correct.
to the house.
That's correct.
And then you said in April of 24, when the divorce was granted, you offered him to come pick his things up, and he refused. He did not come because of rain. And then we arranged for him to come. Did he come on the 7th?
Yes, my children were there.
And
His things were on the back porch.
yeah, you moved on the 7th, you moved all of his stuff to the back porch so he could pick it up. Is that correct?
Mhm.
And then on the 8th, did you have to work?
I'm not sure where I was. I'm not sure if I was at work, but I did send the children. And he did come to get his things.
And were they there ready, available for him?
Yes, they were on the back porch.
And to your knowledge, were they taken when you got home? Did he remove them?
No.
The next day,
Yes.
what happened the next day?
I showed up at the house. I did not know he was going at any certain time. I just happened to go and he was there.
Now, again, this is April of 2024, and the property closed in January of 2025.
That's correct.
December of 2024 closed. Were you already moving out of the house?
I'm sorry?
Okay, in 2020, when did y'all move out of the house? It closed when?
January of 2025.
2025.
Mhm.
So in December of 2024, the month before it closed.
We were slowly moving. We had started moving.
Okay. You were moving because you had to be out before the closing.
That's correct. Well, the house was for sale, and so I had to find somewhere for us to go.
When
We
did the
had a-
house go under contract?
It went under contract a couple of times. I would have to look at my calendar, but it would fall through. And so we went back and forth a couple of times. So I just had to find us somewhere to go to, keep from having to do it at a rushed time.
Okay. So from October, when we came in and entered that order in front of Judge Turnbow,
Yes.
did you find out that he had filed bankruptcy?
I think actually the day I got home from the hearing, I found something in the mailbox.
Well, that-
My mail had been being delayed because of the forwarding issue, but yes, the same day that we came here, I found out that he had filed bankruptcy.
Okay, and the fact, and so you had already listed the house for sale, correct?
Yes, the
Okay.
29th. Yes,
Did you already secure a place where you could go by that time?
yes,
Okay. And so again, did you ever consent to him just coming in the house?
no,
You had his things ready for him to pick up?
yes. Yes,
And on the 8th, he didn't, the 9th, he came back. Was there some altercation? You heard him testify that he showed up and he was angry the day before because you weren't there, but then when you were there on the night, he
our neighbor was there, and no, I just happened to walk up and he was getting his things.
Okay.
I had to walk around the back of the house. I didn't even know the neighbor was there until I
Okay.
walked around the back of the house.
So the house closed in January and you had to be out.
Yes,
Did you have to pack up some of his stuff that he didn't get?
yes,
And where did you put it?
moved it with me.
Okay. We're not asking for the expenses associated with that, are they?
No,
In January and in February, excuse me, I can't even think right now. In April of this year, did you carry some items to Miss Salinas's office?
the children did, yes,
And again, when we had that list, Miss Olivia over there signed off on it.
yes.
So you had to store those because he refused to take them on the day that we agreed to. Correct?
There was things left that I found along when clearing out the house. There was things that I was like, oh, that's his, like things that, weren't his clothes or his stuff from his office. So yeah, there were a few things that in the end, I was like, oh, I'll take these with me because he's gonna want this.
But did you purposely keep or anything that he had requested?
No.
May I just stand beside her so we don't get the exhibit back out?
That's fine. We're about to adjourn for the day. You
Well,
want,
you just finish this up and then it'll be the stopping spot
oh,
just on this. This is the list that they came up with today.
Yeah.
Okay, do you know and we're gonna take the first three, Johnston solid gold class ring, men's gold ring, and a solid gold hat from his team. Do you not even know what those are, where they are?
No.
Y'all moved out of the house.
Yes,
Did you take them with you?
no,
Did you know anything about where he kept his ties in a cubby under his tie?
I knew where his ties were, but the children also helped me pack. I don't know. I have not seen a class ring in years. I don't know that I've seen it and I don't have those items. I do not.
If you don't have a problem with those are discovered anywhere, he can have it.
Sure, like
Did you take them, hide them, steal them, give them away?
No.
Throw them in the trash or do anything with those three items?
no,
These DeWalls, the next series, did you agree for him? Again, the court order says what it says, and he gives his personal items. Nothing specific. Did you believe the DeWalt ratchet and socket set, the drill, the impact drill, the sawzall, the work light, and the leaf blower were his separate property?
No.
Were any of those given to him as gifts?
I don't. I am unsure of that.
Did you take those things?
I have some of those things.
Do you know which ones you have?
Not exactly, but whatever was in the tools that I use.
And are these tools that you use
Yeah.
around the house?
Yes,
Do you believe that was what the intent was in the division,
yes,
that you kept those?
yes.
Softball equipment,
I returned everything that I found in the home that was softball equipment.
and, personalized glove and a black leather glove.
I don't know. There were two gloves that I returned to him. I don't know that I don't know that that was them. I returned everything that was in the corner in the garage that was softball equipment.
Again, you had to lug around the orange kayak, the balance, 450 motorbike, and 2 ladders.
Yes,
Were you able to carry those to Ms. Salinas' office? Did you have a vehicle?
no, I do not.
You agree that those are his and you don't have a problem getting?
Yes, those are his.
but it should be his responsibility to get them.
Sure.
Antique cast iron skillet, do you have a clue what that is or where it was?
I did not even know there was such a thing. I do have cast iron skillets, but I did not even know we had a cast iron skillet from his grandmother. No,
I mean, was it an antique cast iron skillet that was kept in a,
no,
place of,
no.
okay. Autographed 8x10 photos of Star Wars actors, were those retired? He says he's received 3, still have several in his
Everything Star Wars in my home has been returned to him.
state of Tennessee wildlife print, raccoon and an eagle.
I do not have that.
Were they in your home?
They were.
And do you know where they are?
I do not. It was not in the move. It did not get moved.
Okay. Do you know whether you put them in the stuff again today?
No,
They weren't there.
no, that's not, no, that was something we got a long, long time ago. No,
Were they hanging in your home or?
no, it was up in the attic.
Okay, so it's not something you, on the wall?
No, it hasn't been in our home hanging in years.
Various hand tools, hammers, pliers, and channel locks. Were those just tools that you believe you were awarded?
Yes,
The zero turn lawnmower,
yes.
when did you purchase that?
I purchased it for $3,000. It was a used mower. I'm gonna say at least 10, 12 years ago. It's been a very long time. I made payments on it to Terry Small Engine. I don't know exact dates. I could ask them. I paid for the mower.
But after, before the separation,
Oh, yes, years ago.
years ago.
Yes,
And the debt that he says, that's when he says he used it, and then it was worn out, part wore out when he was using it. Was that debt he paid actually something that predated the separation?
yes.
And if.
Our neighbor told him where to take it, and he didn't pay these people for a very long time. Yes,
Red Max Weed Eater,
yes,
you got that?
I do have
You
that.
think that's yours? He was not on any yard tools or anything like that?
I use it weekly.
2.5 ton jack.
I don't have that.
Don't you even know what it was for or what you did?
No,
The garden tiller,
no, I do not have a tiller.
pressure washer,
Yes, I have a pressure washer.
and you use it?
Yes,
He wasn't, it was his uniquely personal one.
no,
Wasn't given him as a gift or purchased?
I
as a gift?
purchased it.
You purchased it?
Yes.
Not for his,
No,
not a gift. Again, when we talk about softball equipment, you don't have any.
no, he has everything.
And then all of a sudden today, he's come up with a Fender P-Bass guitar and hand.
Last I saw that, his oldest daughter had it. So I do not have that and haven't seen it.
Be snippy. His oldest daughter or y'all's oldest? daughter?
Our oldest daughter has that.
Just wanted to make sure there wasn't a child.
So
No.
you're saying the oldest daughter has the Fender
As,
guitar?
at last that I knew, I'm not sure if she still does. I do not have it in my possession.
Do you know? Was it sometime at the house?
It hasn't been in years that I am aware of.
And again, I'm looking at pre-separation. I mean, did she take it after he left?
No, I don't think so. I think she had it before. I'm not sure when. It's not been in the house. I did not move the Fender guitar. No, I do not.
And so your daughter has, it's like you claim to it, was it purchased during the marriage? Was it a gift to him? Was it his premarital?
It was purchased during the marriage.
Okay, so it was a marital asset.
Mhm.
Okay. So do you believe that everything that you got used furniture where you raised 4 kids up in a household?
That's correct.
He got a lot of collectibles.
He definitely did.
Again, we've gone through some of that with, he's not been has he been the most financially frugal individual in the world?
No.
What does he buy these things with money that y'all earned during the marriage?
Yes,
And he got them all.
yes.
How much on a average would you even know how much he was on the computer buying this stuff?
I would not know.
Because y'all kept separate
That's
accounts.
correct.
So if any financial problems befall, do you attribute that to his hobby / side business?
Yes,
You believe that it's fair and equitable, the division of assets that were made at the time?
yes,
Was what you were getting, what he was getting, a roughly equal and fair division based on all of the factors, the length of your marriage, your financial contribution, the fact that there was 5 of y'all, 1 of him, and do you believe that that was a fair and equitable division?
Yeah.
Think other than, like I said, if you find some of these things that you're not in dispute, you don't have a problem him getting them, but you don't have them.
no, I do not have them. What I have, I've given back.
Okay. And again, you have,
incurred attorney's fees as a result of this. You signed a contract paying me $350 an hour. Is that correct?
Mhm.
Your Honor, we would move into evidence. I think I handed it to the court to follow, but I didn't make it
It's the single
exhibit.
page,
The summary page, we would move that in as the next exhibit.
doesn't have a total, was there a second page with total then?
Well, no, because I didn't know what else that, I put that's why I went through and talked about the total, because we put how much she got, and that's only half. And whether or not Your Honor's gonna give him any additional credits. So,
All right,
I
I
passed it.
assume, Ms. Salinas, you have questions and we are done for the day. So
Your Honor, I will have questions.
we'll consult your calendar and we'll talk about when you can come back, finish the threat. You can step down.
Thank
you. I have the 14th and the 15th as regular chancery days. I know they both have things on them, but I don't expect this is gonna take a real long time for y'all to finish up, is it?
Probably not, if she's your only witness. right?
More than
But, yeah,
a
I'm not gonna call the children.
couple of hours, and therefore we'll be here the whole day on this case again, so.
Your Honor, I'm here on both of those days. I have a final hearing on Blanchard and then a final hearing on Matthew Smith. I'd prefer to have it on Monday, the 14th.
Judge, I had to be in front of Judge Wallace on the 14th, but luckily I got that settled. So I'm available on the 14th.
All right, we'll move it to 14th. Let's just set this case first on the 14th. Yeah, on the contested docket. If it's any uncontested matters, we'll deal with them later. All right,
Very good. Thank you, Your Honor.
we are going to adjourn for the day, and we will see you all Monday the 14th at 9 o'clock.
All right.